Tim, while we're waiting, if your staff could maybe call that other defendant.
I just had Rebecca do that, so.
Okay, good.
Thank you.
All right. People of the State of Michigan versus Alex Matthews. This is file 2123694. And he also has 2123688, 2123689, 2123690, 2123691, 2123692, and 2123693. And it's my understanding he's going to enter a plea in this first file, and the others are going to be dismissed. So, Mr. Matthews, if you'd raise your right hand, do you solemnly swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
And Mr. Gabriel, the offer for the record?
Your Honor, Mr. Matthews enters a plea of guilty to this file, count 1, home invasion, 2nd degree, with 1 prior felony, which will increase the maximum. We will dismiss the remainder of the counts in this file. We will dismiss the other files. And as he is presently serving a sentence in the Department of Corrections, we are recommending that the sentence not exceed the minimum guideline score, that the minimum not exceed that scored by the court, realizing the maximum will be the statutory maximum. We also acknowledge that he would get credit for the time from when he was arraigned on these charges, and that the sentence on this case would run concurrent with the sentence that he's already serving. And they get a bit confusing, but that would mean that when the court imposes this sentence, you likely would have a new parole eligibility date by adding these 2 sentences together.
All right. Mr. George, is that your understanding?
Yes, Your Honor.
Mr. Matthews, we had a brief discussion before we went on the record, and I got your personal information and such. But you understand that the offer is that you plead to a charge of home invasion in the 2nd degree as a habitual second offense, which means it carries a potential maximum sentence of, rather than 15 years, 22 and a half years. And then the rest of the counts would be dismissed. And then all these other files that I mentioned would be dismissed. And the prosecutor would recommend this case runs concurrent with the case you're currently serving. Now, when he says it runs concurrent, it means you don't get credit back to that original case, but rather credit from when this case started, which would have been October of 2020, Department of Corrections already. Is that your understanding?
Yes.
Ticking that they didn't get a prelim done until 69 some days or longer after they were brought here. But I also looked through the file and don't find anywhere in the file that there was a notice to the prosecutor by the warden of the Department of Corrections, which would trigger that 180-day clock. So as ridiculous as the statute is and the way the courts have interpreted it, there is no trigger to that until the warden sends the letter, even though we know that they're serving a Department of Corrections sentence. And it's not for me to comment on the wisdom of the legislature or those courts that have interpreted those rules. So I do not find that an issue, as I do not find that the triggering event occurred, and that the delays that have been attributed were due to COVID, them being in lockdown because of COVID, and also the delay in obtaining dates for 3 co-defendants to have 8 prelims and the rest. And we have processed this, and we should have done a better job of getting it set sooner for status, but it's resolved with a plea. Is that correct, Mr. George?
That's correct, Your Honor.
You looked at that issue, I assume, and spoke with Mr. Matthews about it?
We had talked about it, yes.
All right. And Mr. Gabry, is that
That's
correct?
That's correct.
No,
Unmuted. And all of those factors, along with others, entered into this plea agreement.
okay, good. I assume that's why that was such a deal, but I just wanted to put it on the record for those reviewing it, that I did consider that. And you can confirm that the triggering letter from the warden was never received by your office, is that correct?
I can, Your Honor, and I did look at that back when I assumed office, and we're looking at trying to get these cases moving.
All right, thank you. All right, so back to Mr. Matthews. We got to get to the factual basis, and I wanted to cover my bases there before we did it. Again, the information has a date of between 11/9 and 12/29 of 2018. But it only concerns one breaking and entering that occurred at 10474 Walnut Drive in Three Rivers, Michigan. Actually, it says Fabius Township. Did you break into a dwelling at 10474 Walnut Drive?
Yes.
And is that located in St. Joseph County?
Yes.
And it says that you did break and enter or enter without permission a dwelling located at that address, and while entering, president, or exiting the dwelling, committed a larceny. So what happened that night?
I broke into
Or
a
day?
house.
I don't even know if it was day, so go ahead.
I broke into a house and stole some stuff and left.
Whose house was it? Did you know them?
No,
No. And what was the stuff that you took?
I can't even remember the exact items. Some yard tools, maybe?
Okay. You didn't have permission to be in the home, though, is that correct?
No.
All right. Counsel satisfied that, oh, and do you admit you have at least one previous felony conviction prior to 2018?
Yes.
Are counsel satisfied that a factual basis has been established by the defendant's statement of facts?
I am, Your Honor, but I would like the record to reflect that the reason there is a date such as set, that is because on 12/15/18 was the last date this summer cottage was observed by the owners, and then when they returned on 1/4/19, the break-in was discovered. So it's sometime in that time period that this particular cottage was broken into.
Understood. And that's why I couldn't give him an exact date. So sometime in the fall of 2018, you admit you broke into this home in Fabius Township.
Yes.
Okay. Mr. George?
I agree that that's a sufficient factual basis.
Are you the counsel aware of any of the promises, threats, or inducements?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule?
Court has.
Yes, the court has.
I find the plea made is accurate, understanding, voluntary. There's a factual basis, therefore I accept the plea. Set this for sentencing on June 4th. And again, Mr. Matthews, we're going to be doing that by Zoom unless you'd rather have a writ done to bring you here. Would you agree to do it on video, or do you want to be brought here?
Video's fine.
Okay, all right. Okay, so with that, we will check and see exactly where you're at come June. They'll be contacting you to get the updated pre-sentence report done, and then we'll be ready for sentencing in June.